Hello, sir. Can you hear me?
Yes.
Yes. Hi, Brian. How you doing?
Today we are going to be joined by a colleague of mine, part of the Pan-African Debate Society and part of the University of Botswana Debate Society, Mr. Baho Mtimula. I think he has connected.
Yeah, we've already admitted him.
Yeah.
All right, we can proceed. Welcome, Mr. Kwagi.
Thank you, sir.
Right. Dr. Marota?
Yes.
Let's proceed.
Okay. Thank you, everyone. Good day, good morning, good evening, wherever you are. Good day, Professor Milton. Good day, Brian. Good day, Mr. Mola. Today we're going to discuss the Myanmar Mayhem overview coup, what is going on over there. You see all the international implications related to this event. Today we are going to have the participation of Professor Dr. Milton, who is the founder, director of the Center of Justice. Also, we have Brian Rampane. He's the candidate attorney for international law. He worked as a researcher for the ICR Justice Center Africa, and we are going to have they're going to join us in the meanwhile Professor Darwar Kanatripati. He's professor of international criminal law from India. We are going to have the presence of Professor Rabat Kudamela, Professor Primpan, Professor Alessandro Nacciotti, Professor Maria Tiani, and Marit Kaur. She is an international expert. She's the chair for the ICC, and also Counsel Brenda Okote. She's an expert in international law. Okay, Professor, I pass the floor.
All right. Are you done, Dr. Marota? All right, thank you very much, Dr. Marota, and thank you, Counsel Brian. Thank you. Let me allow Professor Sripati to get in. Professor Sripati is joining us just now, and it's a pleasure having you, Mr. Motimola. Our viewers and listeners all over the world, we welcome you to this session. And we say good morning, good evening, good afternoon, wherever you are on this part of the globe, on any part of the globe that you are in. We are coming live to you today to discuss a very pertinent issue that is currently an issue of concern globally. That is the Myanmar post-coup situation mayhem. You will recall in a retrospective trajectory that we did discuss Myanmar mayhem a couple of months back, but that discussion centered largely around the Rohingya difficulties that the government had with that population. Today, however, we are focusing on the post-coup situation in that country. As I indicated, we have a number of stories, stuck stories and reports emanating from Myanmar currently. Now, just to begin very fast, to take you back, the 2008 Constitution of Myanmar, which was actually designed by the military regime, the military junta that we have right now in control of the government, had some three key features that I wish to bring out. The three key features were that within that constitution, it provided a framework, a legal framework that ensured that the military retained their absolute authority. They retained their autonomy away from the civilian administration. That was one thing. The second feature of that particular constitution, the 2008 Constitution of Myanmar, was that the military retained veto power, which enabled them to be able to veto any legislation that, in their view, was not going to advance their interest. And thirdly, the military retained power over the key ministries or portfolios within the government that, of course, mattered for them, such as the Ministry of Interior or Security Ministry, such that in effect, in sum, the military was actually still in control of the entire system of administration in that country. In consequence, actually, this retention of powers and vetoes that we have just indicated, the autonomy, enabled the military to continue to enjoy absolute impunity. Now, last year, that is 2020, we had elections in Myanmar. And during those elections, the National League for Democracy emerged as a party, as the winner of those elections, overwhelmingly won the election, beating their rivals, the Union Solidarity and Development Party. It is instructive to note that the Union Solidarity and Development Party is a party that is largely controlled or run by, the cronies of the military junta. Most of them are, ex-soldiers, retired generals. And so the current military junta favored the Union Solidarity and Development Party. Being not happy with the outcome, on February 1st, 2021, just a couple of days back, the military declared a state of emergency in that country to last 1 year. They were not happy with the results, and they alleged that there was widespread voter fraud in the elections to the Union Parliament. So we see that as a consequence of that declaration, as we will be able to indicate, the constitution that allows for the declaration of a state of emergency was actually designed by the same military persons. And it has been indicated, many commentators have indicated that the military have indeed violated the same constitution that they designed. How is that possible? Let's look at Article 417 of the same constitution. That article provides for how the president should be able to declare a state of emergency. If you look at the Article 417 of the Constitution of Myanmar, the 2008 Constitution that is, the president is supposed to declare a state of emergency after coordinating with the National Defense and Security Council. That is a body which consists of about 11 persons, and ordinarily about 6 of them would be military personnel and the other civilians. But you can see that at the time when that council could have convened, the rest of the other civilians were not available. Either they had been detained or banished, and none of them were part of that council. In a way, actually, therefore, the declaration of the state of emergency was largely unconstitutional. And the other requirement under that same constitution was that once that declaration has been made, the president is supposed to inform the parliament. They're supposed to be able to brief and explain to the parliament as to how and the justification for the state of emergency being declared within the country. But you will note that the state of emergency was strategically declared on the 1st of February, while the parliament, the old parliament, ceased to have its term or tenure expired just a day before that. And the ensuing parliament was meant to start off the same day that the declaration was made. I think this was just a strategic design by the military at that point. So we had no parliament in Myanmar to be able to be explained to in connection with the state of emergency. So in a nutshell, what we are saying is that the military, in effect, violated its own constitution, the constitution that it helped to design. And so the state of emergency was unconstitutionally declared in that country. So the other point that we need to bring across is that the entire system within Myanmar, owing to all these absolute powers, autonomy, and as we said, impunity by the military, we have a situation where the military still has very significant control over the judiciary. And we know that actually the rule of law in that country is very weak. So the question would be, why would a government, why would the military junta, the military clique, go to the extent of, carrying out a coup when really they had the power? In effect, they were in control of the system. There have been a lot of theories advanced to explain this, but among them, possibly one plausible explanation would be that it was a personal presidential ambition on the part of the military chief, that is General Klein, Arun Klein. You'll forgive me for the pronunciation. The general, understandably, was meant to retire imminently. He was about to retire, and they think that this was a last-ditch attempt for him to be able to cling to political power. And so how was he attempting to cling to political power? By advancing trumped-up charges. We realized that Aung, the state councillor, and the cabinet were all arrested and detained, and some of them have been charged on trumped-up charges before the courts. And as we say, the military still retains very significant control of the judiciary. And we know that as a consequence of this crackdown or clamping of the politicians and activists, a number of citizens in Myanmar went to the streets to be able to protest the coming in of the military regime. And we also know from the reports that the clampdown has really been very brutal, brutal indeed. We don't have exact figures, but it is estimated that roughly around 730 civilian lives have been lost during this short period of time by the military having to clamp down on them and shooting peaceful protesters. And it's also estimated that well over 4,300 civilians have been injured in the process. The United Nations Security Council has condemned the situation as it is in Myanmar. And we also have reports that a number of civilian activists and politicians have in exile constituted, formed, political organizations, some kind of government in exile to be able to advance the interests of those who are against the military regime. So as we talk today, you must have seen in the media all over the world that the ASEAN, that is the Association of Southeast Asian Nations, were meeting in Jakarta, Indonesia, and indeed the military chief, that is General Arun, was invited to this meeting. Of course, it met with a lot of protest and condemnation by other interest groups, but he attended the meeting of, it's normal about 10 leaders or so. I understand the leader of Singapore and Philippines, I'm not very clear about that, but those ones who could not attend, but they sent representatives. Anyhow, we had a meeting going on today seeking peaceful resolution to the matter or the situation in Myanmar. So against this background, today we are privileged to have a panel of professors who are going to discuss this issue, and they're going to give their views in the next probably less than 30 minutes left now. So the questions would be really, what are the implications? We are narrowing down as international criminal lawyers, what would be the implications for international criminal justice process? What aspects of the Rome Statute could have been contravened? What crimes possibly, and what steps would be taken, would have been appropriate in the circumstances under the United Nations Security Council referral trigger mechanism under Article 13, and a number of other issues to address the repression of human rights in that country. Thank you very much, and I welcome you all panelists. I welcome you, Professor Sripathi, who has just arrived, and I welcome you, Councillor Manrit, after a long time. It's good to see you. All right, we have a very few minutes left, only about 20 minutes, and I just welcome all of you to participate, and I hand you back over to Dr. Marota. Thank you very much. Dr. Marota.
Thank you, Professor Milton. Welcome to Madrid.
Yeah, thank you.
Okay. Well, I thank you for that great introduction, Professor Milton, and for what is going on right now in Myanmar. So what we need to discuss right now is the international implications that the military coup is going to have in international relations with other countries. First, starting with the Asian community. So to that aspect, I can see here that Manrit or Professor Sripathi can give us from their experience in the Asian community how is going on over there, the reaction against this anti-democratic situation going on in Myanmar. Professor or Manrit, you are welcome to give us some approach from.
Okay, good evening, everybody.
Good evening, Professor.
Good evening.
Good evening. It is evening in India. I've said good evening.
Good evening.
So we are all meeting after a long gap, a long time. So it is good. And moreover, now Professor Milton has cut down the time limit also to 20 minutes. So probably I'll get about 5 minutes to speak, Professor Milton.
Yeah, or less actually. And
That's okay. Now, coming to the situation in Myanmar, civil wars has been a common thing on the territory of Burma, because Myanmar was earlier known as Burma. And for a brief period in the past, it was occupied by Japan. And then the East India Company, when they came to India, they waged wars against the Burmese army and then occupied Burma. And that is how Burma, now Myanmar, had become a colony of the British Empire. And then after that, however, Myanmar is not a member of the Commonwealth nations, though it was a colony of the British Empire, like other colonies. Now, in 1948, Burma, Myanmar got its independence, and then in 1962, the military rule was established. From 1948 to 1962, there was a kind of a democratic regime that was established. But in 1962, the military took over. And as I stated earlier, Myanmar has a long history of civil wars and human rights violations. It's not new to Myanmar. However, in 2015, for the first time, after a long gap from 1962, general elections were held, and the National League of Democracy, NLD party, won the elections. And then after completing 5 years term in 2020, the NLD again won the elections. And the leader, of course, is Aung San Suu Kyi. But in February 21, 1 year after the government coming into power, there was a military coup, and the military again took over the nation of Myanmar. And human rights and internal conflicts have been a common feature as far as Myanmar is concerned. And abusive regimes have ruled Myanmar. Then the United Nations and other major international human rights organizations have issued reports of widespread and systematic violations of human rights. And in fact, the General Assembly also passed a resolution against the Myanmar and also urged the military rulers in Myanmar to respect fundamental human rights and fundamental freedoms. And to this effect, a resolution was passed by the UN General Assembly. And there have also been reports of child soldiers being inducted into the army by the military rulers. And when the question was raised on the international front in 2012, the military released 42 child soldiers. So this is pretty much evident that the military rule in Myanmar was inducting child soldiers, which is actually banned as far as the rules and norms of international law is concerned. Then there has also been reports of slavery and human trafficking, mostly human trafficking in children and women, and genocide allegations and crimes against the Rohingya Muslims, because I had spoken a little about the crimes against Rohingya Muslims in Myanmar in the previous discourse, where these Rohingya community was treated as a third-rate community in Myanmar. They were not considered full citizens of Myanmar. They were not even considered associate citizens. They were treated as third-rate people. And finally, they were driven out of Myanmar by the military regime. And they had to escape to Bangladesh and then to India. So we know what happened after that. The main question or the reason why this particular discourse is being held today is whether any action can be taken by the International Criminal Court against Myanmar. However, the fact remains that Myanmar is not a party to the Rome Statute. And past history tells us that in many cases, the ICC has badly failed in the case of non-state parties. But there is a ray of hope in the sense the ICC, in fact, has approved investigation into the crimes that are being committed in Myanmar. And the ICC judges have also authorized the investigation. The prosecutor filed an application before the authorities, that is the pre-trial chamber. And then the United Nations also has established a kind of a investigative team, which is known as the United Nations Independent Investigative Machinery or Mechanism for Myanmar, IIMM, has been established by the United Nations, and they are doing their work of collecting evidence in respect of crimes that are being committed by the military rule in Myanmar. Then very recently, about 2 or 3 days back, even the European Union has imposed sanctions against Myanmar, stating that there is evidence of crimes against humanity being committed in the region of Myanmar or on the territory of Myanmar. Now, another development that has come up is that a country of ousted civilian lawmakers in Myanmar are looking at the question if they can ask or request the ICC investigate any crimes against humanity that have been committed after 1st February 2021. the request is in doubt because of the fact that Myanmar is not a member of the Rome Statute. However, Article 12, Clause 3 of the Rome Statute is something that the Myanmar legal experts are looking at, because under this Article 12.3, Myanmar could lodge a complaint with the Register of the ICC to accept the exercise of jurisdiction by the court. But that could again be contested by the military rule that is reigning in Myanmar. So this will definitely give rise to complications and, in fact, a controversy on the international front. But nevertheless, efforts are going on. The whole world is witness to what is happening on the territory of Myanmar, and
okay, Prof,
almost all the nations.
Prof, I'm not
Yes.
intending to cut you short, but you've raised very critical issue. We have only about 9 minutes to go. You've raised a very critical point about Myanmar not being signatory to the Rome Statute. In other words, they're not part of the Rome Statute. So for any investigation to be, for any trigger mechanism to take place, they have to either be referred by state party or pure motu by the prosecutor himself or herself, or by the Security Council under Article 13B. Can we, at this point, just bring in some of our colleagues into the debate so that we don't have them cut short? The Prof has introduced a very, very important point about the trigger mechanism. Can we have some contribution towards this? Can we have Manrit, who is a counsel at the International Criminal Court. She is a lawyer at the ICC. She's not been with us for a while. Maybe she has something to add on. We have Counsel Brian, who is now a fully admitted attorney of the High Court in Botswana. And we have his colleague, Borago. We also have Dr. Marota. So please, anybody would want to come in to contribute to that, please step in. We have only about 8 minutes left. Thank you.
Yeah. As Mr. Professor is telling, and so I'm just adding 2-3 lines in this section, because under Article 15, as I am reading the Rome Statute, under Article 15, the 15.1, the prosecutor may initiate investigations on the basis of the information on the crimes within the jurisdiction of the court. And so under Article 15, on the 14th of November 2019, ICC judges already authorized opening of an investigation into the situation of the Bangladesh and Myanmar. And here I am again discussing one more case of the ICJ, that is the case of the Gambia versus Myanmar. And that was case related to the Rohingya Muslims. The Myanmar is actually, what was the actually issue? The issue was the government of the Myanmar, a predominant Buddhist country, denies the Rohingya citizenship and then excluded them from 2014, and refusing to recognizing them as a people in their country. So it seems that it is illegal immigrants from the Bangladesh. So in the United Nations Secretary General, the Antonio Guterres describes it as the situation in the Bangladesh. It's one of the most sensational situation, and we considered it as a textbook of the cleansing. That is the cleansing of the ethics, which comes in the category of the genocide. And it is the most relevant and the sensational example of the genocide crime. And so that can I get 5 minutes and 2-3 minutes more, and
yeah, you have about 2 minutes more, because we are left with 6 minutes.
Sorry, actually, I'm already coming.
Only 6 minutes left.
So many days, and I'm already late.
But fine.
Yeah, so I'm just reading the main lines of that case of the Gambia versus the Myanmar. The case against Myanmar was brought to the ICJ in the November, and by the Gambia. That is on the behalf of the small community of the Muslim community. and against the Muslim Rohingyas, and they want the citizenship, they want their status and the proper status as a citizen in the Bangladesh. And the order of the court.
I'm not cutting you short, but there's a point that you raised which is very critical. We have current, proceedings going on, international proceedings, as even the Prof indicated. Apart from the ICJ, which is the Gambia versus Myanmar, we have an ICC investigation being carried out right now. But as you rightly put it, these investigations revolve around Rohingya. And the referral was on the basis of cross-border, because Bangladesh is a party to the ICC. And by virtue of that, the investigations proceeded because some of these crimes were carried out, by virtue of cross-border. That was a very important point. Before you continue that, I would want somebody to come in on that particular point. How would Article 13B come into play with respect to the Security Council? I don't want us to skip that very important, trigger mechanism. We should not be caught up with time before we touch on it. Would anyone want to talk about it?
May I?
Yes, Prof.
Yeah.
You have only 2 minutes.
Normally, in the case of non-state parties, since the ICC cannot exercise jurisdiction, the other option is that the Security Council can make a referral in respect of non-state parties to the ICC. But for the ICC, for the Security Council to take a decision, because it is an important substantive issue, 9 affirmative votes, including the 5 votes of the permanent members are required. And in the case of Myanmar, a Security Council referral would also fail, simply because of the fact that Russia and China would not support the resolution which will be proposed to be passed by the Security Council. Because China has always supported Myanmar and Russia also has a kind of a soft corner. So they would not. Because till today, whatever is happening in Myanmar, Russia and China have not commented anything. While the whole world is condemning, these 2 countries have remained quiet. So it simply shows that they are in support of whatever is happening in Myanmar.
That's a very important contribution, Prof.
That is
Thank you very much. I think that is a common challenge we are having with the trigger mechanism under Article 13B, because we have the permanent members of the Security Council that exercise the veto power. Councillor Brian, do you have anything to add on before we get back to Norit or any other person, Dr. Marota or Councillor Brian?
Yeah, the ICJ, it was a ruling of the ICJ that the provisional measures against the Myanmar will be taken, and the last one, it was the country also has to submit a report, to the ICJ within the 4 months, with additional reports every 6 months until the final decision of the case of the Myanmar situation.
Thank you, Council. Thank you, Council. We have only 2 minutes. Council Brian, can you say something?
Thank you very much. I only have just one little contribution. Is in the absence of either a state party or the prosecutor or Security Council referring the matter or taking that mandate, it's going to be very, very difficult for the International Criminal Court to have jurisdiction or to exercise anything over a non-state party, just by virtue of just a simple principle of law of caveat subscriptum of he who signs must be bound. So if in the instant case we see that they have not committed themselves to be ruled by the Rome Statute, it is going to be very difficult for the ICC to exercise its jurisdiction. Thank you.
Thank you very much, Council. Council Brian is now fully admitted attorney. In the remaining 1 minute, can we just find out what are the possible crimes under the statute that could have been committed by the military repression, brutal repression of the civilians? Or Dr. Marot?
Yes, well, when I was brought up is that one thing that we can trial this military coup is under universal jurisdiction. We can evoke that principle under the ICC or any exile Myanmars in other European countries, as we have seen in Germany and Sweden against Syrian persons who violate international humanitarian law. So there is a door that can be opened under universal jurisdiction. And what crimes I can see here? Well, crimes of aggression against the own people of Myanmar. Probably we do an investigation over there. We can see torture or any other kinds of mass atrocity crimes that probably occurred under a military coup. So that's the path. I think universal jurisdiction it's a good thing to evoke under situations where the ICC doesn't have subject matter jurisdiction to see the cases and can proceed.
Thank you very much, professors. We have run out of time now, including, of course, crimes against humanities. As you've
Humanity,
seen,
yes, that is the main
contribution. And I thank you very much for all your time, Professor Sripathi, Dr. Marota, Council Marit, Council Brian, and we have a new participant, Montemola. We also have somebody we have not been able to see the picture of, Cody. Thank you all our viewers for having been with us today, and we say bye-bye for today. See you again next time. Bye-bye.
Yes.
See you. Thank you.
Bye-bye. Bye-bye.
Thank you. Bye.